Hi, Phil Silberman from the Silberman Law Firm here, and today we're going over statutory durable power of attorneys. We've got one in front of us. This form is typically used for someone to give financial power to an agent to make various decisions, such as bank accounts, real estates, things like that. It's called statutory because it arises out of the statute. I've got a form in front of me here today. I think I got it from Health and Human Services from the Texas government website. But you'll notice that this form is actually taken directly from the code, hence the term statutory durable power of attorney. And you can see this is the form in Word document, but it comes directly from the statute. I've got the estates code pulled up here. You'll see it's chapter 752 of the estates code, and it comes directly from the code, and it includes the form. The legislature actually puts it in the code, and it's probably the most common power of attorney used in the state of Texas for doing things like granting financial powers. So let's go ahead and get started reviewing the specific sections of the form. You start off with the basic notice section here. Powers are broad and sweeping. It kind of tells people what this form is used for. And then you get into, unless you revoke, specifically you die, your agent resigns, or there's a guardian which terminates this power of attorney, you're going to appoint this person. So you fill out the name of the person right down here. That's the name of the agent, your appointee, and then this is your name as the principal of the power of attorney. You can have a co-agent. Usually people don't. That gets a little messy. Normally people just appoint one agent as their power of attorney. And then you get into the grant provisions. And to grant specific powers, you're going to want to initial whatever you're giving them power to do. So for example, in real property transactions, you may just want to give them that power. So you would initial there for real property transactions. If you want to give them all powers for personal property, stocks, or banks, whatever you're doing, you initial all of them. Note, if you're just giving them power for real property transactions, then this document needs to be recorded in the real property records. That's part of the recording statute in the property code, I believe. Or you can just do all the powers initialed here. You get into special instructions, whether you check whether you want your agent entitled to reimbursement of expenses or not. You get into co-agent selection here. Again, I don't recommend it, but if you have co-agents, you can have them act independently, which they're just off doing their own thing, or they have to act jointly. It's probably safer for them to act jointly, or you can have them act by majority. The form gives you that power. So, and you can enumerate specific legal instructions here if that's something you want to do. So unless you direct otherwise, it's going to have this power of attorney is going to take effect immediately. You can make this a springing power of attorney. So, for example, the power of attorney can take effect upon your disability or incapacity at a certain, or it can take effect at a certain time. That's called a springing power of attorney in Texas, and it has some defaults if you don't select A or B. And you get to kind of some more boilerplate language on what happens if your agent dies or different events. Then you sign it, you date it. It does need to be acknowledged in front of a notary, and here's your notary block here where the notary will go ahead and sign and put their stamp on it there. And then you get to some important information for an agent. Tells you about the agent's duties. Your agent needs to know they can, in fact, be sued. They need to act in good faith. They need to not breach their fiduciary duty. An agent for a power of attorney is required to act in the best interests of the principal. One of the things that we see most happening here is you'll see an agent want to deed themselves the real property that belongs to the principal, or real estate, or you'll see agents that want to put property in their own name. That is a really, really bad idea. And while technically not illegal, it will create all kinds of title issues and open the agent up to various lawsuits. So this is a disclosure on agents' duties and responsibilities. And then you get into that tells the agent termination if the principal dies. You no longer, the power of attorney automatically ceases. That's a common misconception, is that somehow power of attorneys go on after death. That's not true. When the principal dies, there's no more agent authority. The principal can revoke the power of attorney and some other various things. Liability of the agent. If the agent violates anything, does any bad acts, the agent can of course be liable for these types of errors or omissions or acts of negligence or intentional acts. So you don't really want to be an agent unless you have the best interest of the power of the principal in mind. So that completes our basic survey of the Texas statutory durable power of attorney. As always, contact a competent estate planning attorney or real estate attorney if you've got questions about the use of this form, or you want to have an attorney draft that for you.